Hello everyone, this is MAHEK, a legal internet LEXIS and company. Welcome back to our channel. This video in continuation my previous video dealing with how a state can exercise its jurisdiction in international domain, and as we all know, there are four ways how a state could exercise such jurisdiction. Those four ways are first is territorial principle, then we have nationality principle, then we have protective principle, and in the last we have universality principle. In my last video, I have discussed what does the state jurisdiction means, what are those territorial principle and then nationality principle. In this video, I'll be continuing with protective principle and this universality principle. So protective principle is concerned with the national security of the state, and it is one of the examples of extraterritorial jurisdiction. Extraterritorial jurisdiction means where the state is trying to apply its own laws on some other on a nation on citizens of other person who was never within the limit and who is outside the territory of India and is not even related to even nationality or some other side. For example, the in territorial principle, the crime was being committed within the territory of the nation. In nationality principle, the crime or the offense was committed against the citizen of the state itself. However, for applying this protective principle, the state is applying its jurisdiction extraterritorial. It's not within the limits of the state. It's just for the protection of the threat. A state is claiming his action against a foreign or an alien person not related to the state in any sense. What happened in this? If due to some actions of some foreign person, there is a threat to the national security of a state arises, the state can claim jurisdiction or can take action against such person. For example, if a person, a citizen of China residing in Singapore residing in Singapore and maintaining its business of drug trafficking in West Bengal of India. After acknowledging such fact, India can take actions against that person even if the person is not within the territory of India, even that person do not owe a citizenship of India or is nowhere related to India, but the wrong he is doing against the whole country. It is the wrong against the whole country and is against the national interest of the state. Therefore, India can take actions against that person sitting in Singapore. So this was the protective principle. Now the last principle is universality principle. It is also one of the extraterritorial principle. Here the offense is not even against the state itself as is was in the protective principle. What happens in the universality principle, as the term extends, the offense is universal. And it is a wrong committed against all the states of the earth, of the world. So the wrong has been committed against all the states. So any state can come forward and claim its jurisdiction or can take actions against such person. For example, if there are some war-like conditions has been arising by some state, then any powerful state can take actions against that state where such conditions are being arising from. For applying this universality principle, generally treaties and conventions are being signed and are being put forward to deal with such conditions. For example, some peace-like conventions are there. Some humanitarian purpose conventions and treaties are there. These are for all are concerned with this universality principle. For example, actions taken by the USA against Pakistan. Pakistan is not doing any wrong against USA, but they are promoting terrorism. Terrorism is an offense, is a wrong against all of the nations. So USA has put blacklisted, has put sanctions against Pakistan. So that's one of the examples where the action has been taken under the shade of this universality principle. This was all about how the state can take jurisdictions, or what are the ways available to a state for taking a jurisdiction in international domain. Hope you like this video. Thank you.